Welcome to Immigration Quicktake. This is Ellie Rutledge with the American Immigration Lawyers Association. Late Friday, U.S. District Judge Dolly Gee ruled that the government was not meeting the terms of the original Flores settlement, which sets national standards for all children regarding their detention, treatment, and release. The decision should signal the end of mass incarceration of mothers and children seeking asylum. And here to discuss the decision is Crystal Williams, Executive Director at AILA. Crystal, thanks for joining me. First off, what did this ruling say?
Well, this ruling was actually an analysis on contract law because it related to an old settlement agreement. So therefore, the judge found that the government was in breach of contract by breaching the settlement agreement. And because of the breach of contract, she issued an order to show cause to the government, requiring that the government answer by August 3rd why she should not proceed with several different elements of the order. First element, to release the minors, to release the children that are in detention. Second element, that the children should be released as a first priority of release to a parent. And what's important here is that she also said that the parent can include a parent who was accompanying the child and has been in detention or is being detained with the child. Third element, no child can be detained in an unlicensed or a secure facility. That would mean Dilley, that would mean Carnes, that would mean Berks, that would mean all the places the government has been detaining children and their mothers. Fourth, they must release the parent with the child unless the parent poses a significant flight risk that cannot be ameliorated by either a bond or other conditions of release. And of course, unless the parent poses a danger to the community or a danger to national security.
Thanks, Crystal. What happens next?
Well, next, the government has to respond by August 3rd, i.e. next Monday. Then the plaintiffs have to respond to the government's response by the next Monday, by August 10th. And then, unless the government comes up with something really clever in its response, the government has 90 days to implement the judge's order. Now, the government could seek a stay. However, by putting the order as an order to show cause, a stay is highly unlikely here. The government could appeal and ask an appeals court to stay the order. We don't know whether that's going to happen or not. As far as we know, the government is all just thinking about it at the moment. Stay tuned. We'll be seeing some more action in the next few weeks, I'm sure.
What is the most important task AILA will turn to now in order to prepare for the ruling's implementation?
The fact is that if the government has 90 days to implement, government being government is going to take at least 90 days to implement. In the meantime, we have to keep doing what we've been doing. We have to hold their feet to the fire. We have to make sure that all of the provisions are being implemented, that they're not trying to undermine any piece of this order. We have to make sure that the women are represented, or as many of them as we can, get them representation, and advise them on what they need to do once they are released. The ordeal is not over once they're released. They still have to go to immigration court. They may have conditions of release that they will need to comply with. What we've already found in Dilley is that the government is not doing a good job of informing the women that they are releasing what their obligations are, what they need to do next. And so if the government can't do it, AILA's going to have to do it, AILA and our partners in the CARA project. But we have to be the lawyers, as we always are, and we have to make sure that all of these families are getting good advice, good legal advice, good advice as to what their obligations are.
Thanks, Crystal, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.